Welcome to The Explainer. Let's jump right into a fascinating case today. We are unpacking a super high-stakes legal showdown that went all the way up to the Constitutional Court of South Africa. It's the case of Trevor B. Giddey versus J.C. Barnard and partners. And look, this isn't just some dry story about numbers and contracts. It is a really dramatic clash between a fundamental human right, the right to access the courts, and the pragmatic and honestly often harsh financial realities of our legal system. It's what we're calling a true $100 million paradox, and the way the courts finally resolved it is absolutely brilliant. To really grasp the gravity of this case, we have to start with the stakes: $100 million US. That is the staggering claim launched by the liquidator of a bankrupt company against an accounting firm. We're talking about a colossal sum of money here. The liquidator argued this money was lost from a trust account, which directly led to the company's ultimate ruin. This is exactly the kind of massive lawsuit that takes years, whole armies of lawyers, and just immense resources to litigate.
But here's the hook, right? How does a monumental $100 million lawsuit, a case of this sheer magnitude, get completely paralyzed by a demand for a mere 500,000 South African rands? That is the central paradox we're going to untangle today. Because on the surface, it almost seems absurd. How on earth can a fraction of the total claim just shut the courtroom doors before the trial even begins?
Section 1. The $100 million lawsuit. Okay, let's look at the core players and the facts here. We've got a company named Sedrima Explorations, and they've been bankrupt and in liquidation since January of 2001. So the liquidator, Trevor Giddey, steps in and sues the accounting firm J.C. Barnard and Partners. Giddey is claiming the accountants basically failed to conserve $100 million that was held in trust for Sedrima, and that this specific failure caused the company to collapse. But before they can even get into a courtroom to argue about who actually lost the money, the accounting firm fires back. They demand 500,000 rand in upfront legal security before they'll even step into the ring to defend themselves. What followed was just a relentless journey through the South African legal system. This single procedural issue, whether a bankrupt company had to actually put up that 500,000 rand, sparked an absolute war. First, the Johannesburg High Court ordered the liquidator to pay the security. Well, the liquidator fought this. He tried to appeal first to the High Court itself, then moved up to the Supreme Court of Appeal, and ultimately took this procedural fight all the way to the highest court in the land, the Constitutional Court of South Africa. Section 2. Security for costs explained. So, to make sense of this, we need to talk about Section 13 of the South African Companies Act. This law is actually an exception to the normal rule. Usually, if you live in South Africa, you can sue someone without having to pay any money upfront to guarantee their legal fees. But Section 13 gives courts the power to order a bankrupt plaintiff company to secure the defendant's legal costs before the case proceeds. Basically, if the company cannot pay this security, they're entirely blocked from moving forward with their lawsuit. And this right here perfectly illustrates the intense legal friction at play in this case. On one hand, we've got Section 13 of the Companies Act, which is specifically designed to protect defendants from spending millions on legal fees that they can literally never recover from a bankrupt plaintiff. But then, on the other hand, we have Section 34 of the Constitution. That section guarantees everyone the fundamental right to have their disputes resolved in a fair, public hearing before a court. Naturally, the liquidator argued that forcing a bankrupt company to pay upfront security violated this exact constitutional right of access. You know, what's really fascinating about this dynamic is how it completely subverts our usual expectations. We almost always want to think of a bankrupt company as this helpless David and the big corporate accounting firm as Goliath. But the courts recognize a totally different reality here. A bankrupt company can actually be a really dangerous Goliath. Think about it. If they sue, they have absolutely nothing to lose. If they win, they get a massive payout. But if they lose, the successful defendant is left holding the bag with massive, irrecoverable legal bills because the company has no money to pay them. The normal rule that the loser pays the legal costs just doesn't deter a company that's already broke. So Section 13 exists to stop that kind of risk-free, vexatious litigation. Section 3. The Constitutional Access Right. Let's dig a bit deeper into Section 34 of the Constitution. It ensures that disputes are resolved in a fair public hearing. As Justice O'Regan noted in her judgment, this right finds its normative base in the rule of law itself. It basically ensures that society has peaceful, regulated mechanisms to resolve conflicts instead of just chaos. So shutting the door on a plaintiff simply because they happen to be bankrupt feels, intuitively, like a major threat to a foundational democratic pillar. But here's the catch, and the Constitutional Court made this very clear. The right to access courts is not absolute. For courts to actually function fairly and efficiently, they have to have rules. There are strict time limits and procedural steps that are completely mandatory. If you fail to observe these rules, it can entirely end a claim or defense. As long as these rules, just like Section 13, are properly applied and are constitutionally justifiable, they are entirely valid. Sometimes limiting access is actually necessary to maintain order and fairness in the system itself.
Section 4. The Judicial Balancing Act.
So how do higher courts handle this? First, you have to understand the appellate hands-off rule, or what the court technically calls a discretion in the strict sense. Because ordering security is a procedural matter, higher courts, like the Constitutional Court, won't just intervene simply because they might have made a different choice. They will only overturn a lower court's decision if it hits one of three specific blunders. Did the lower court act unjudiciously? Did it base the decision on wrong facts? Or did it apply the wrong legal principles? If the lower judge did their job properly, the higher court keeps its hands off. So what exactly is the job of that lower court judge? Well, they have to perform an incredibly delicate balancing act. The judge must weigh the plaintiff's risk, meaning the injustice of being prevented from pursuing a legitimate claim, against the defendant's risk of winning the case, but suffering financial ruin from unrecoverable costs. To actually balance this out, the judge looks at real-world factors. Things like, will ordering the security actually terminate the lawsuit? What attempts has the plaintiff made to get funding? And, crucially, who actually caused the plaintiff's financial difficulty in the first place? Which brings us to the real turning point in the Giddey versus Barnard case. It's what we call the evidence gap. When the liquidator opposed that 500,000 rand security demand, he actually made a fatal error. He failed to expressly state and prove that the company would be completely unable to pursue the litigation if they were forced to pay. And even more importantly, he didn't show the court any proof that he had gone to Sadrema's creditors or shareholders, the actual people who stood to win big from a $100 million payout, and asked them for financial backing to cover the upfront security. To be fair, the liquidator did have one incredibly powerful counter-argument up his sleeve. He claimed that the accounting firm's alleged failure to protect the trust funds directly caused the company's bankruptcy in the first place. It's a seriously compelling point, right? I mean, how can a defendant demand financial protection from a plaintiff when the defendant's own alleged misconduct is the very reason the plaintiff is broke? Section 5. The final verdict. Ultimately, the Constitutional Court delivered a definitive verdict. They found that the original high court judge actually did a perfectly legal and rational job. That lower judge didn't just ignore the liquidator's claim that the accountants caused the bankruptcy, he weighed it in the balance with everything else. But crucially, the lower judge noted that if this $100 million claim was actually as strong as the liquidator said it was, the creditors who stood to benefit from it could easily pull together the 500,000 rand to fund the security. So, because the High Court acted judicially and relied on the correct principles, the Constitutional Court dismissed the liquidator's appeal entirely. The demand for security stood. In reaching this decision, the court anchored their reasoning in the profound importance of the justice system itself. They reference this incredibly powerful quote from Justice Makgoro: "The right of access to court is a bulwark against vigilantism and the chaos and anarchy which it causes." This really reminds us why this highly technical procedural debate matters so much. Ensuring that our courts are accessible to the public, while at the same time protected from being abused by risk-free litigants, is absolutely foundational to maintaining an orderly society. So, as we wrap up the explainer, it leaves us with this final, provocative thought to ponder. What is the true price of justice when protecting one party's finances literally means shutting the courtroom door on another? It's a delicate, deeply complex reality of our legal system, one where our fundamental rights have to constantly be weighed against harsh practical realities. I hope you found this breakdown insightful, and definitely keep questioning the balance of justice in the systems around you.